and gentlemen, I hope that everybody's doing well. My name is Gerald Kinosi and I'm a legal advisor. And I'd just like to thank each and every one of you who have logged in and who are a part of, the last part of the series. Thank you so much to all those who have been with us from the beginning. And today is unfortunately the last part of the series. I'm just going to ask you to please bear with us for like 2 minutes or so while the other people are busy joining in to this presentation. But please bear with us for like 2 minutes or so, and we will be starting shortly. Thank you so much. Thank you, ladies and gentlemen, for joining us, being a part of this presentation. I'd like to welcome you all to the Legacy Blueprint. What this is basically a 4-part series that provides information so that an individual could properly plan their estate. Should something happen to you, today, you should know that your affairs are in order. So I'm just going to quickly recap on what we covered in the first week, second week, and third week as quick as possible. Now, this week's presentation will be quite short because administration of estates isn't quite a large subject, because most of the things that have to do with the actual administration of the estate gets handled by the attorneys. So we will be covering, the overall process as to what happens, although we can't obviously go directly into the specifics because each estate is different. Okay, so we will be covering what happens when a person passes away, what it is that you need to do in order for you to properly administer the deceased estate. Okay. So again, welcome to the Legacy Blueprint. It's brought to you by Legiscore Legal Consultants and Advisors. My name is Gerald Kinosi and I'm a legal consultant and advisor. And this series is brought to you by Legiscore as well as Retrosevetsa, which is a company which is based in Lefering that does community development. And also their nonprofit organization called Roscott. And the series is dedicated to ensuring that we provide enough information to people, especially in our communities, to prevent, fights, disputes once a person passes away. We want to ensure that should something happen to you, your estate is properly handled. It's properly managed as well, so that you leave behind a legacy that your dependents and your children could live off of for generations to come. Okay, so what we will cover today, is basically the administration of a deceased estate, right? Administration, estate administration 101, like I said, when we cover the basics as to what exactly happens when you pass away, how the estate will be administered. We'll be talking about the Master of the High Court and their role in all this, which is very important. We'll be talking about the executor's journey, so the executor's responsibilities throughout this whole process. And we will be speaking about the difference between letters of executorship and letters of authority. I know a lot of people have heard about letters of authority, but what do they actually, what is meant by that? And what is the use of a letter of authority? So we're going to be getting into that briefly to explain the differences. Pardon me. We'll also be speaking about the key responsibilities of the executors, like the collecting of assets and dealing with the creditors. We'll also be speaking about what happens if the estate is insolvent. And lastly, we'll be speaking about the final steps once the estate is being wound up and what will basically happen in those steps. So thank you very much once again for being a part of this. If you have missed part 1, part 2, part 3, they are available on YouTube, and we will be emailing you these presentations so that you do not miss out on the vital information. All right. So now we are going to be recapping part 1. Okay. So part 1, we were speaking about the types of unions in South Africa. Now, it's important that when you are planning your estate, you understand which type of union you're gonna, utilize and what type of marriage regime you're gonna choose. So we spoke about civil marriages, which are traditional monogamous, so it's a man and a woman. We spoke about matrimonial property regimes in community of property, out of community of property, with and without accrual. We covered that. And we spoke about civil unions, which are similar to civil marriages, but they were specifically created to cater for same-sex marriages. Although you can still get married under a civil union when you are different sexes. So heterosexuals can also get married under civil unions in the same light as civil marriages. The same marriage regimes apply. You can get married in community of property under civil unions, out of community of property, with and without accrual. Pardon me. We also spoke about customary marriages. Now, the customary marriage is unique in such that they are polygamous unions that are allowed. So a man can have more than one wife, but unfortunately, a wife can't have more than one husband. It doesn't work in that way. So it only applies to men getting more wives. So we spoke about the requirements of a valid customary marriage, which means customary law needs to be observed. In other words, there needs to be uncles who meet the uncles of the bride, and there needs to be a negotiation. There needs to be lobola paid. Both the parties need to be of age, which means they need to be 18 and above. If one of the parties are less than 18, they need to get express consent from their parents or their guardians in order for them to be in that union. They also need to be competent to marry. Now, this actually applies to all the unions, not just customary marriage. And I will explain that in a moment. So the fourth union that we covered are life partnerships. This is girlfriends, boyfriends, cohabitation, Fatenset, whichever way you want to refer to it. Now, there are no automatic legal rights in these types of relationships. A girlfriend and a boyfriend, when a boyfriend or girlfriend passes away, they do not have rights to any each other's things automatically, right? So for you to protect such a union, a life partnership, you need to have life partnership agreements expressed. They need to be written down, stating that I've chosen whoever to be my life partner, and we share so and so. Those types of things. Now, in order to solidify a life partnership, you need to make sure that you write a will. Should something happen to you, your partner must be protected, and your partner must have access to your things. So in other words, you should leave your things for your partner. That's how you can solidify a universal partnership, right? A life partnership, rather. Now, we also spoke that a partner can actually claim from another person's estate under certain conditions, like, for instance, if an unjustified enrichment claim, let's say, for instance, so another partner, and the partner could claim that money from the deceased estate. Now, general principles for all unions. Prohibited degrees of kinship. We spoke about this in detail. There are certain people that you cannot marry that are closely related to you. For you can marry people in your bloodline, like your sibling, your mother, your father. But however, you can marry those who are not too close, like your cousins. And also another thing, by affinity, you cannot marry your mother-in-law, you can't marry your father-in-law, you can't marry your daughter-in-law, your son-in-law, but you can marry your sister-in-law or your brother-in-law. That one is allowed. So those are the types of degrees, prohibited degrees of kinship. We also covered that understanding the types of unions is foundational for effective estate planning. So you need to make sure you understand the types of unions you're getting into in order for you to properly plan your estate. Okay, so that was part one. Now in part two, the recap, we spoke about understanding how trusts work. Okay, so we spoke about what is a trust. A trust is a legal arrangement where assets are held by a trustee for the benefits of the beneficiaries. We said that imagine a box. Imagine a box, maybe like a toy box, and it has toys inside. Now the box is a trust. The toys inside are the assets of the trust, right? Now the person with the key is a trustee. The trustee decides when the box gets opened. Do you understand that? The trustee has the power to control the assets within the trust for the benefit of the beneficiaries. Now, if it happens that the trustee does not have authority from the master of the High Court to make a specific decision, it will be declared null and void, right? So, in other words, a trust is a box with assets inside, and the children that take the actual toys and enjoy them, those are the beneficiaries. So the trustee is basically safeguarding these assets in order for the beneficiaries to benefit from them, whether it's for generations to come, whether it's a specific time period, that will depend on the trust. Now, we spoke about the parties as well. There's a founder, the one who creates the trust. You can create a trust either two ways, either through your will, which is a testamentary trust, or you can create a trust, inter vivos trust, through a trust deed. This one you create while you're still alive. A testamentary trust can only be created through your will, so which means you have passed away by that time. Okay, we spoke about, this is what I was saying, types of trust, testamentary trust, and inter vivos is as I was explaining now. Now we spoke about the responsibilities of the trustees, their fiduciary duties. So being a trustee is actually an office. It is actually a post or a specific vacancy that has requirements, and the trustee can be held accountable for their actions. So it's not like a trustee could do whatever they want with the specific assets. They cannot dispose of them, they cannot sell them, or they cannot do whatever they want to do, with the assets without the express permission of the master of the High Court. And in some instances, the beneficiaries own those assets, so they need to get permission from the beneficiaries as well. But we spoke about that. Please go to part 2 on YouTube and briefly go through that, so you can get a full understanding of what it means to be a trustee. Now, the benefits of having a trust: asset management and protection, because these things are not, your assets are no longer in your name. Nobody can actually claim them, and unless, for instance, if you are insolvent or for tax purposes, so they can actually lift the corporate veil and go after them as though they are yours under those situations. Okay, so you can also save on estate duty. That's the tax that you pay after you pass away, the tax that gets deducted from your estate after you do pass away. Right. Now, the benefit of having a trust is that it is flexible, and you yourself can decide on what it is that you want to happen, how you want the assets to be managed in the trust. It's sort of like a living will. Okay. And efficient administration, so streamlining asset transfer outside the estate winding up process. So you're going to save on transfer fees when it comes to immovable property like houses. And so you don't have to basically transfer into any other person's name, because the trust is going to be living in a way. So as and when people pass away, they will enjoy the benefits of those assets. You don't have to transfer it into whoever's name. It's going to end this whole squabble of, family houses, people fighting for houses, killing each other and stuff like that. If it doesn't belong to anyone, but if everyone can enjoy, then that's a better setup than if it belonged to one person or two people and they fought over that specific thing. So that's basically what we covered in part 2, week 2. For trusts. Now, for a will, we just spoke about why a will matters. It gives you control over your legacy. It ensures that your assets are distributed according to your wishes. So you have freedom of testation, right? When you die with a will, it means that your estate is testate. When you die without a will, it's intestate. So it means that it will be distributed according to the Interstate Succession Act, right? We spoke about that last week. What makes a will valid? We went to the strict legal requirements. The legal requirements are that it has to be a written document. It needs to be signed by the testator, which is you who's writing the will, and there needs to be 2 or more witnesses to sign and attest that indeed the will was created, and they serve as a witness to actually witness that you yourself wrote it. Now, there are other requirements as well, that you need to be of sound mind. You need to do it unilaterally, so you can't have somebody assist you. You can't delegate this unless perhaps it's a legal professional. But however, whoever assists you should not be a beneficiary of the will, as well as the people who are testifying should not be beneficiaries of the will. Otherwise, they stand a chance to forfeit whatever it is that they were going to benefit from the will. That is a very important point that we made last week. So the common pitfalls, the sessions highlighted how crucial it is to avoid common mistakes, like the ones that I just mentioned now, improper signatures or vague wording, which could lead to the will being contested. I said last week that when you write a will, you must write a will. After somebody reads it, they should not ask themselves questions. It should be clear. It should be clear. Use plain, simple language. Do not use language that will make you yourself confused. Use plain, simple language. If need be, write it in your own language. A will that is written in your home language is not invalid. As long as it is clear, there can be a translator who will translate it. So that is what we covered. We also deal with the state focuses on family. Because if you pass away with children or with a wife, your estate will be distributed to your wife and your children. But there are certain calculations and certain, procedures that are followed when that happens. So, yeah, we also spoke that it's beneficial to have a will, because if you don't have a will, your assets, your estate will be distributed not necessarily the way you want it to. So, for instance, if you have no children and you and your brother have been fighting for years, and you have no wife, and you pass away, everything's going to go to your brother that you don't like. And I'm sure that it is something that you won't be happy about, in the afterlife. So it's better to have a will to make sure that everything that you have will be distributed according to the way that you want to be distributed. Okay, so that's what we did in part 3. Before now we move on to the next part, I want to ask if there's anybody with any questions. I'm opening up the floor. Do you have any questions? Put up your hand. If you have any questions, please. I'm just going to give you like 1 minute to type or to decide. But if you have a question that you don't want to ask now, please write it down and you can ask at the end of the session. So is there anybody with any questions? Okay, while you guys are asking the questions, I want to ask, Can everybody see and hear? Please, am I audible and can you see me properly? And I'm not jamming or anything like that, right? Uh, uh, on my section, can everybody see me properly? Can everybody just give me a thumbs up or just comment in the comment section if there's any technical difficulties, please? So can I just get a thumbs up if you can hear me and see me properly, please? Ladies and gentlemen, I think we just had a statement. We apologize for that. It's asking you 2 minutes. Let us sort it out quickly and we'll be back. Please give me thumbs up if you can hear me. We are just quickly sorting it out. Please can I have 2 minutes and be back shortly. Thank you. Okay. Thank you, ladies and gentlemen. Apologies for that little technical glitch. Hopefully we have it sorted out now. Can just give me a thumbs up if you can hear me properly. Please let me know, or just comment in the chat that you can hear me clearly, please. Can everybody hear me and see me clearly? Okay. Right, so cool. If anybody has any issues hearing me, please can you just notify our moderator, Tsidimoso, and she will alert me if you guys are having issues hearing me. Okay, so now we are going to move on to the topic of today, which is the administration of estates. Okay. So, administration of estate. What is it? This is what we are going to get into today. So it is basically the legal process that begins when somebody dies, when they leave an asset, when they leave assets and liabilities behind, or when they leave a will, if somebody does have a will, when they do pass away. Essentially, this process ensures that assets are collected, debts are paid. So if somebody passes away with debts, this process will ensure that the creditors get the money that is due to them. Does it make sense? Is everybody with me? So one must ask, who are the beneficiaries? It's just like in the trust or in the will, the beneficiaries are the people who are going to inherit your assets. Now, this will basically depend if you have a will or not. If you have a will, then the assets are going to be distributed to whoever you choose, how you choose. If you don't have a will, it's going to be distributed according to the Interstate Succession Act. Like I said before, the state gets to decide who gets what. Okay. Now, the beneficiaries could become the heirs, people who inherit, or legatees. So basically, if maybe you want to donate or give somebody who's not part of your family something, your car, some money, or if you want to donate something to someone else, you refer to them as legatees. So basically, this is what the whole system, the whole process is about, is ensuring that your estate gets administered. Whoever needs to get what gets, whoever is entitled to get whatever they need to get, gets it at the end of this process. Okay. So now we're going to move on to the next page. How are assets distributed according to this estate administration process? The assets are either distributed according to a will when you have a will, or if you don't have a will and you pass away, they get distributed according to the Interstate Succession Act. This is what we covered last week. Okay, and the entire process is governed by the Administration of Estates Act of 1965. So we're going to start with phase one. When somebody passes away, the first thing that you need to do is phase one, which is to report the death. Okay, so you report the death. It must be reported to the master of the High Court. That is step one. So normally the closest family members are the ones that do this, and you must submit a notice of death and the original will. It's the sort of what the process that you take when you're going to claim from the policies. They want a notice of death and the particulars of that specific person who has passed away. So you do the same thing, the IDs, the death certificate, all of those things, you take them to the masters. And if there's a will, you ensure that you submit the will as well to the master of the High Court. That is when this process gets started. Now, the appointment of the executor. The executor of the will is the person who's going to ensure that the will, the administration of this entire estate gets, the process, gets completed and the estate gets wound up. The executor's job is to overlook that entire process. Okay, and the Master of the High Court is responsible for this appointment. Now, either the Master of the High Court can choose the executor for you, or the executor can be chosen through a will. Either way, the Master of the High Court needs to appoint that person as the executor of the estate. All right. If there's no valid will, the Master appoints someone based on a legal set of rules. And the executor acts on behalf of the deceased person and the estate. So like I said, the executor needs to make sure that the estate gets distributed and the creditors get whatever they need to get. The executor makes sure that all of those things are done before the winding up process. That's the last stage. So now there are two types of letters that you're going to get. It's a letter of executorship and a letter of authority. Now we're going to discuss these two. So what is a letter of executorship? It is a formal document from the Master of the High Court that authorizes the executor to wind up the estate, okay, which means collect assets, pay the debts, like I said, and then you distribute the inheritances at the end of everything else. So this is a full-scale estate administration process. Okay. Now the document doesn't need to be submitted for things like property transfers. Instead, the deed of transfer will simply refer to the executor in the estate of the late person. Okay, so that's basically what the letter of executorship is. Now we are going to also look at the letter of authority. I know a lot of people have heard about a letter of authority. So this letter of authority is a less formal document, and it is for small estates, which are typically less than 250,000. Now, a designated representative gets these letters instead of an executor. Okay, so this person who has the letter of authority is the one that is going to oversee the distribution of that estate. So it's a less formal, it has less formalities, basically, than the letter of executorship. Okay, so it's a small case study. Mrs. Lamini dies without a will. Her estate is valued at 150,000 rand. What type of authorization will the master issue? We just spoke about it now. Can somebody just answer this question? Remember, there are two types of authorizations, the two letters that I spoke about. Which one will Mrs. Lamini, the master, which type of authorization will the master issue for whoever's going to be taking over the duty of administrating the estate? Can somebody just answer that in the questions for me, or raise up your hand, please?
Let's have a land.
Okay, yeah, you can. Yes, Letabo, you can go ahead.
Hi, it's letter of authority for this scenario. Can you hear me? Can you hear me? I'm muted on the side.
Letabo, can you hear me?
Yes.
Okay, Letabo, we can't hear you. I'm not sure if it's on our side or on your side, but can you type the question in the chat, please? Can you type your answer in the chat, please? What type of authorization will the master issue if Mrs. Lamini dies without a will and her estate is valued at 150,000? I just spoke about the letter of authority and the letter of executorship. So which one will be issued? Will the master of the High Court issue? Can somebody answer me, please? Letabo, can you hear me?
Can you hear me? Can you hear me?
Okay, Letabo, we seem to be having some issues. Can you please just come again?
Can you hear me?
We can hear you. You can go ahead. Okay, Letabo, please go again.
Hi, can you hear me?
Hear you now. Please go ahead.
Now I was saying it's letter of authority for this scenario.
Okay, thank you so much. That is correct.
Okay.
Thank you very much, Letabo, for that. Apologies for the slight technical issues. But yes, the answer indeed is letter of authority due to the fact that it is less than 250,000. Okay, thank you so much for that. This means that it will be a simpler and faster process. Okay, so now we are getting into phase 2. The phase 2 is the executor's duties. Okay, so once authorized, remember the executor needs to be authorized by the master of the high court. Once they authorize, they start doing the work. So the work, key responsibilities of an executor is to take control. They need to gather all the assets of the estate. They also need to advertise for creditors to submit claims. Usually they do this in the government gazette as well as in the local newspapers. Wherever that person has passed away, they need to advertise for 30 days. They need to also determine the solvency to check if the estate has more assets than debts. Remember, when you are insolvent, it means that you have more liabilities than assets. So they need to check and make sure that they know whether their assets are more than the liabilities or vice versa. Okay. Now they also need to ensure that they have an estate bank account. That's where all the monies are going to go to before they get wound down and distributed to the people who are going to inherit. Okay. And they also need to create the liquidation and distribution account. This is the account that they need to make sure that they have. It's very important for the process of the estate administration process. Now we're going to get into the liquidation and distribution account. So what is that? The liquidation and distribution account. It is a detailed financial statement which will be prepared by the executor. And this lists all assets, debts, and how the proceeds are to be distributed. It's a very important document. It also includes income and expenses that occur after death. Right. Its purpose is to show exactly where all the money from the estate is going to go. That's very important, especially since the person who passed away does not have a say in what happens to the money. So they need to make sure that the estate, the monies that are going to be coming in are going to be handled properly. That's why it's important to have a trust. When you have a trust, you will make sure that when you pass away, any income that you are supposed to get, you can direct it to the trust, because your children, your spouses, your children or your spouse will benefit from that in the end. That's why it's important to have a trust as well as a will. Public inspection submitted to the master for approval. Advertised for public inspection, so anyone with an interest can check it and object if necessary. That's why it's important to advertise in the government gazette as well as then local newspapers. If nobody contacts the executor or claims from the estate, then the process could continue. So dealing with insolvent estates, it's what I was speaking about, insolvency. It basically means that you have more liabilities than assets. Okay, so you need to report the insolvency to the creditors immediately. That's what the executor needs to do. The creditors have a chance to tell the executor to handle the estate under the Insolvency Act. Okay. So deemed state of sequestration. Sequestration happens when your estate is insolvent, and the creditors can therefore start to sequestrate your estate. So in most instances, there is a person could either voluntarily, it's called voluntary sequestration, or the companies could actually, sequestrate you by force if you do owe them. So there are two. I don't want to get into that too much because it's, insolvency law and stuff like that. But if creditors don't choose the Insolvency Act route, the executor will handle it as if it were insolvent. Okay, so they need to follow the specific procedures that are in the Insolvency Act. Assets are then liquidated and distributed according to the rules of the insolvency law. It was just what I was saying now. Okay. So after all this, we move to the phase 3, which is final requirements. Is there a hand? For that. Does anybody have any questions so far before we move on? Please raise your hand. You can type it in the comment section as well. Raise your hand.
Hi, can you hear me?
Yes, I can hear you.
No, my question is what happens if you're the executor you nominated passed away?
Okay, thank you so
Did
much
you get
for
that?
that question. It's Letabo. Okay, Letabo, thank you for that question. So what happens in that situation if you have nominated an executor in your will and unfortunately that executor passes away? What's going to happen is the Master of the High Court will have to appoint an executor for you. So basically they choose an executor based on a set of rules that they follow, but they will appoint one for you. So every estate, when you do go and inform the master of a death, there has to be an executor that will be appointed, whether it's through the will or the master can also choose to appoint one for you. So an executor will be appointed definitely for you. So have I answered you, Letabo?
Yes, thank you.
Have I answered you properly, Letabo? Do you have any more questions?
No, I'm fine. Thanks. My reaction is not working here.
Thank you so much, Letabo.
Yeah, okay.
So come again? Thank you so much, Letabo. Okay, no problem. Thank you so much, Letabo. Much appreciated. Does anybody else have another question that they would like to ask before we move on to the final requirements? We're all good. Okay. Right. So now we are moving to phase 3. Phase 3 is the final requirements and the executor's release. This is when the estate is being the final steps for it to be wound up. So now the final step, this is the final phase after the liquidation and distribution account has been approved. Okay, the executor must provide proof of advertisement, show proof that all creditors have been paid. So maybe they can request paid up letters from the creditors. Show proof that all beneficiaries have received their inheritances. They can probably do proof of payments and the likes. Provide a zero balance bank statement for the estate account. So in other words, the estate account, after the estate is being wound up, it needs to be at a zero balance. Right? Am I making sense? Now, executor's discharge. Once all of these final tasks are done, the executor gets a filing slip from the master. This marks the official completion of the winding up process. So basically, that's what happens at the very end. You get a filing slip from the master that says this estate has been successfully administered and everything is completed, all the monies have been paid, and this chapter can now be closed. Right. So now moving on to the master of the High Court. They play a very critical role in the administration of estates. So basically, the master of the High Court is the supervisor. They supervise the entire process. Okay, they supervise the entire administrative process to ensure that all the requirements have been met before it gets wound up. Now, the key functions of the master of the High Court, they are administrative. So they deal with the filing and the handling of all the documents pertaining the deceased estate. Discretionary, they're accepting or rejecting wills. They carefully check the liquidation and distribution accounts, ensure the process is fair and protects the interests of the beneficiaries and the creditors. That is the role of the master of the High Court throughout the estate, the administration of estate process. Okay, now I want to further emphasize, we spoke about this last week, but I want to emphasize it more. Without a will, your estate will be distributed according to the Interstate Succession Act. And this means that the law gets to decide who gets what. And that may not always be your wishes. So I would encourage you to draft a will. You can check part 3 of the legacy blueprint. It will instruct you on how or what the legal requirements are, what the invalid formats of a will are, because now some people still think that you can create a will through a video, through an SMS. You can create a will on an online document, and those are invalid formats, which means that that will is not valid and it will not be executed. So it needs to be written like a written document, a paper. It needs to be on a paper because you as the testator need to sign it. So it needs to be signed by you. Okay. And the third requirement, legal requirement, is that you need to have 2 or more witnesses to sign the will. Now, if you do need assistance with drafting a will, LegisCore legal consultants and advisors are here for you. If you need assistance with creating a trust, we are here for you. We have a panel of attorneys that do assist us with any court procedures here at LegisCore legal consultants and advisors. So we do assist you with that. We assist with family matters as well, family law. If you are divorcing, if you want, to maintenance matters, we assist with that. And the cornerstone, or should I say, the important services that we provide are labor law as well as corporate law as well. So we deal with the compliance of the business to ensure that your business complies with the law, BEE. The contracts, we review contracts and draft contracts. We draft policies for your business to ensure that you avoid liability and save money. And we also do CCMA representation. We do employee and employer relations. And we also provide training to the employees, specifically about Labor Relations Act, as well as Basic Conditions of Employment Act. So yeah, that's basically what we do at LegisCore Legal Consultants and Advisors. And we invite you to reach out to us, for personalized consultation. Don't leave your loved ones vulnerable, confused. Avoid having this family drama or family houses. Just have a trust. Ensure that everything is protected. Your assets are protected under the trust, so that should something happen to you and your children in the future, your legacy that you have left behind continues for generations to come. Okay. So if you need any assistance with any of these things that we have covered in the past 4 weeks, please do reach out to us for a consultation, and we will be assisting you. Now, I am offering a free 30-minute consultation for everyone who is available today. You qualify based on you being a part of this presentation today. So we do have an attendance register and stuff like that, but we will be providing you the free 30-minute consultation. In that consultation, I will be advising you on which way is better, what is recommended, especially when it's pertaining to estate planning. But you can contact us for any of the fields of law that I've just mentioned to you. Okay, so now I am very grateful that you have been with us. Those who have been with us from day one, thank you so much. Today is the last day. If you would like to see this again, we would recommend that you do go on YouTube and watch all of them to have a full understanding so that you make proper choices when it comes to estate planning. Okay, so are there any questions? If you would like to contact us, the contact details are on the screen. And if there are any questions, we are now opening the floor up to you. Raise your hand, type in any question. Yeah. Letabo, you can go ahead.
Yes, so I missed the first 2 sessions that you had. So you're saying I missed that. You say they're available on YouTube? Your first 2 sessions. I'm saying I missed your first 2 sessions. So are they available on
yes.
YouTube?
YouTube. They are,
okay.
yes.
So
what's going to happen? Okay, so what's going to happen is that we are going to email them to you. I know some of you received emails today and yesterday as well. They already have, if you scroll at the bottom, they already have the 3 past sessions, but we are going to send another email with all the 4 sessions. Okay, but for those who did not get the email, you just go on YouTube, search my name, Gerald Genosi. I have a channel, and you will see them there. They are there. So you just need to go on YouTube, Gerald Genosi, and you will see the part 1, part 2, part 3. It's there. In a few days, part 4, which is today, will also be there. Have I answered you, Letabo?
Yes, thank you so much. Thank you.
No.
Thanks.
Okay, no problem. Is there anybody else with a question? You can even ask me things from part 1 if you didn't understand, for those that were with us. Raise your hand, or you can type in the comment section, in the chat, sorry. There are no questions. Okay, great. So everyone, thank you so much, ladies and gentlemen, for being a part of the series. Today is the last of the 4-part series. Like I said again, those who are part of today's presentation, you will get a free 30-minute consultation with me. We will be providing you with the link for you to book and all of that after the presentation is done, before the end of today or by tomorrow, and then you will have access to claiming that. But unfortunately, it's not available forever. Please ensure if you do want the 30 minutes, you book by tomorrow, just so that we can schedule you properly and we can have a proper one-on-one consultation. Okay, so those who are here today, please, we will be checking the attendance registers. Those who are here today with us in the presentation, you do get a 30-minute consultation, free consultation, 30 minutes, all right? So thank you so much, everyone. Please do contact us on WhatsApp on the number on the screen, 067 091 2887, if you have any questions, and we will do our best to answer them for you. If you want to schedule a consultation, a full consultation, you're also welcome to do that. You can just send us an email on gethelp@legiscore.co.za, or you can also contact us on WhatsApp. But thank you so much, everyone, for being a part of this. And we do hope to see you soon. In the coming months, we will be doing another series for SMMEs. for small business owners. We'll be dealing with compliance, how to draft profiles. For those in the construction industry, we'll be talking about CIDB, NHBRC, all those types of things, but they are coming in a couple of months. We are currently in talks with Rotoseveta and Roscott, who have partnered with us in this initiative. We are in talks and we are currently planning it. But everyone who's here with us today, you will be getting emails as and when that happens, so that not only your personal life is covered, but for those who are business owners, your business will also be covered as well. So we'll be speaking about compliance. We'll be speaking about labor relations in the business, because a lot of people are unaware, and a lot of companies that go to CCMA lose a lot of money because they are unaware of certain things that they are supposed to do, like policies, disciplinary codes, and all of those things. But nonetheless, we will be in touch with you. But thank you so much, everyone. Please have a lovely week, the rest of your week, and we will be in touch. We will be emailing you the link for you to book your free session, and we will be in touch with you as soon as the business incubation, should I say, begins. But thank you so much. Have a great day and stay blessed. Thank you.